Welcome to Legal Bytes over Coffee, an ENS podcast where legal insight meets coffee conversation. I'm Priyanka Raj from the ENS TMT team, and every 2 weeks I'm joined by a guest from across our African offices or an industry partner or a client to discuss what's happening at the intersection of tech, regulation, and business. Together, we unpack the stories making headlines, the challenges emerging in practice, and the contractual and governance questions organizations are navigating in an increasingly digital world. Pour yourself a cup and let's get into this week's Legal Bites. On this week's episode, I'm joined by Dr. Bernard de Bernard, an IP executive at ENS with a special interest in software patents. Bernard specializes in assisting clients in protecting their inventions and furthermore also advises clients on the commercialization of these as well. His experience includes specification drafting, prosecution, and litigation of both patents and registered designs, and having completed his MSc in pharmaceutical chemistry and PhD in inorganic synthesis and computational chemistry, Bernard's technical areas of expertise include pharmaceutical, chemical, material science, and relevant to today, software-related inventions. Bernard, welcome to the podcast.
Good morning. Thank you so much for having me.
It's a pleasure. Let's get the doctor out of the way. Tell me more about the doctor part of my little introduction of you. What is that? It's not very standard for a lawyer to be a doctor as well.
Yeah, well, I'm not the real type that can save lives. I initially studied chemistry and I didn't actually know what I wanted to do. And we had a bit of a lecture during my honors where they spoke about IP law. And since that day, I was kind of on that journey. But it's quite at that time, it was quite difficult to get articles. So I literally studied my way out of a problem. When I eventually got articles, I was finished with my PhD in chemistry, and then I jumped across the pond, started studying law while I did my articles, and I've never looked back since. And it's such a great field to be in, new inventions every week, and I get to mix law and science. It really is a great career. I would recommend it to anyone that would like to blend the two.
It's not a conventional path, and it's really interesting. I think that you're straddling these two areas so awesomely, and I think very well suited for your focus area as well.
Yeah,
Yes.
I got lucky in the sense that my final project was actually a mixture of chemistry in the lab, and then also with your nice intro, you touched on it. I did a bit of simulations where I would look at the interactions between molecules and do some calculations, and it really has helped me quite a bit in my field because, yeah, as we will touch on, software patents are quite a big deal today.
That's really cool. So you're a double nerd basically, not just a legal nerd, but a science nerd as well.
Yeah, no, I'll accept that.
Okay, so before we get into today's discussion, we always start with coffee, and I'm gonna ask you, how do you take yours? And then I'm gonna ask you to guess how I take mine. So how do you take your coffee?
I like my coffee black, but I do have a guilty pleasure if I get enough discovery points. I buy one of those, or what would you say, exchange one of the points for one of those cafe lattes.
Oh, nice.
But I like it with almond milk at Kauai. I hope I'm saying it right. So that would be my guilty pleasure.
Oh,
And then
yeah.
yours, you want me
Yes,
to guess yours. I
yes,
should know this because I sat next to you at the
yes.
workshop a few weeks ago, but I might be failing because I didn't pay attention. I'm gonna guess a cappuccino or a filter coffee with hot milk.
Yo, that is
How
very
close am
good.
I?
No, no,
Is
no,
it?
you're very good. And that workshop started very early, so I was downing that caffeine. Yeah, I think you're the first person to guess it correctly. So well
What have
done.
other people been saying?
They
Black
they
coffee.
all they all guess like loads of sugar or something sweet, and I'm like I don't know. I don't know what that says about me. Like initially I was thinking maybe I just come across as like sweet. I'm like, actually, I don't know what that actually says about a person if people are consistently guessing it.
No, I'm glad I got it right.
Yeah, but I do like Willie's has really nice flavored lattes. Like I like their hazelnut latte and their vanilla and so on. So I guess the sweet does come through there through all the syrups that they use, but no, generally just a normal, as you say, cappuccino or normal coffee.
Yeah.
Great. Okay. So our next segment, Bernard, is called Tech Trends. And I start off with this segment just before we get into anything that's too deep or heavy. And I think for both of our areas, it's quite easy to get into, deeply technical things. But I just want to check in with you and your space of practice by looking at what's happening on the ground in the world of IP and software patents. What's going on?
Yeah, cool. I think it is important that we keep our discussions not too technical because it might be some nice advice to people if we actually keep it to simple examples in their everyday lives.
Yeah.
So yeah, in my space, it's changed quite a bit over the last few years. When I initially started as I think today they call it CLPs, but I was a candidate attorney at the time. Um, I filed mostly chemistry and mechanical patents. So clients would come to us, they've got an invention, it's some kind of tool to help your everyday life, maybe something to strain water more easily in the kitchen. It seems very simple, but a lot of these inventions are actually quite ingenious. So that was one part of the practice when I started. The other part was mostly chemistry and pharmaceutical patents. So think things like cosmetics or maybe some kind of catalyst to output some kind of fuel. But over the last 3 years, the landscape has completely changed. As I mentioned at the beginning of our discussion, luckily I had this experience in software. So the last few years, it is absolutely ballooned the amount of software patents being filed across the world, including South
Mm.
Africa. So there's this little graph that shows the trend of AI patents, which obviously is related to software patents. And I think the graph shows 2005, there was a few hundred patent families, and today it is literally thousands every month being filed. So it's just this exponential trend. So
Mm.
it really is dominating the space in South Africa. A lot of software patents being filed more so than chemistry patents. It's flipped a bit on its head. So it wasn't quite clear when something is patentable as a software invention. Our Patents Act also actually says that you can't patent software as such, it says, but that just means you can't patent the code in the software. You have to patent the underlying invention or the system or the method. And where it was unclear about 2 decades ago, there was a few important decisions across the world that actually provided some guidance on when something is patentable as a software invention. And I think after those important decisions were made, it basically opened the floodgates for a lot of these patents. And today, my practice is about 90% software patents, if not more. And these patents are purely software, machine learning, AI related. I think you will also agree with me. AI is a bit of a buzzword.
Yeah.
Um, Not everything is AI. You can't just have three simple steps in a Python script and think it's now
Yeah.
AI. It's a bit more complicated than that. And I think even some of the models that look very fancy are still very far from being labeled as AI. But um, yeah, sometimes it is just a buzzword, but sometimes I've seen very, very cool inventions. But just maybe some simple examples to show what would be patentable
Yes, I
as a
was actually going
software
to ask,
invention.
like, what
Yeah,
is a good patentable example?
cool. I think just generally something that's a software invention. It could be as simple as some kind of algorithm that receives data and then it is transformed by a model that learns over time as it is trained with more data sets, and then it provides a very unique output related to the data. Think something like maybe users have specific buying trends on some online platform, and then over time, this model learns from their spending habits, and then it produces very user-specific products to increase sales. So I think everyone can relate to that.
Yeah.
And they're just a bit more of a technical example, but I always love to use this example when I give talks on, how AI is being incorporated or finding its way into the field of patents. And IP is a radiologist started working with an AI company, and he basically took probably decades of X-rays of his patients that developed breast cancer. And
Mm.
he trained this AI model with these X-rays. And after it ingested all of this training data, it was actually capable of predicting breast cancer 10 years earlier than the doctor could. It could look at the pixels on these images more efficiently. And that is just such a great example of where an AI invention that was patented could really change our everyday lives. I think it's such a nice example of a software related patent. So yeah,
That
I think
is,
those are some
yeah.
nice examples.
Yeah, those are cool examples. And to ask what might seem to you as an obvious question, but I think a lot of people might not really appreciate what happens if you don't patent something?
Mm, yeah, and it is a bit of a everyday problem I see in my practice. So
Yeah.
we might drill on this point a lot during our discussion, but patents and designs are very time sensitive. So you can only file them before disclosure. So if you make things public, you're very excited about your project, it's going to make a lot of money and you want to invite investors. So you make a LinkedIn post or you speak to your friends or family or whatever the case might be. That could completely ruin or destroy your chance to file a patent. And what happens then is um, a lot of the times you get a competitor and they might have a bit more resources and they just put a team of developers to the task of reverse engineering and copying your invention. And now you come to me and you say, this third party has copied my invention and I now want to file a patent to protect myself. It's too late. You really should file a patent before you disclose anything to the public. And if you didn't, and you made it available to the public, they can actually legally reverse engineer your invention and copy you. So patents are really such a strong tool to stop third parties from copying you. There are other things to consider. If they blatantly copy your code, you can have some recourse there in terms of copyright. But copyright, as we always call it, a bit of a black box. It's quite difficult to prove in court. Whereas a patent is a legal document that gives you a very strong right, and it's deemed to be a valid patent when you enforce it. So don't rely on copyright. I would rather advise always file a patent or design before you disclose anything to the public. I
All
hope that
right.
answers your question, huh?
Yeah, yeah, it does. It does. Thank you. And I think it's a lot of people. I mean, I've been in those conversations with people. Everyone has an idea, right? Like of what they want to do, and then it really means so little if you're not able to actually commercialize it and protect it.
Absolutely. I agree.
In my space, this development came up. I mean, this episode will be published in about a week or so after we record. But around the time of recording, which is mid-April, the Consumer Protection Act regulations have actually been amended just 2 days ago. So that's about on the 15th of April. And it's very interesting. I'm very curious to see how it's going to shake things up because in terms of the regulations, any person And we obviously interpret that very widely to include corporate entities. But any person who wants to actually send direct marketing to a consumer now needs to be registered on this sort of national registry under the regulations. And there's a fine for registration. And, being registered means that you have to also make sure that you're not sending marketing communications to anyone who has opted out of receiving marketing communications, and you yourself as an entity have to be fully registered. So registration means your full name, your contact details, everything needs to be included. So we read it together with what Poppy says about direct marketing. So all the things that say, you can't send something to someone if they don't agree to receive it, or if they don't want to receive it anymore, they can tell you to stop. Those rights remain unchanged. This is really just introducing a mechanism to exercise those rights. So I think it's really interesting. I think a lot of organizations have struggled, especially in the wake of Poppy, to continue their marketing activities. For a lot of organizations, it's their bread and butter. It's one of their main sources of revenue, is being able to send marketing communications, and historically to do it without needing opt-in consent. Where the default is you have to ask, not the default is you have the box pre-ticked. So I think it's going to be interesting. I think a lot of our clients are going to have practical issues as well with figuring this part out. There's a lot of proactive measures that have to be taken. You can't just, click the reply all, or you send to all your contacts. You really do have to check that you're sending it to people that firstly haven't exercised their right to say stop, I don't want to receive your communications, and also haven't actually added or opted for blocking, to be blocked on this registry. So I think it's going to be interesting as a consumer, wearing my other hat as just a normal consumer, not a lawyer. I'm very excited. If I can stop these calls from organizations, that'll be great. So look, but I at the same time, a lot of the marketing calls also work well for me if they're done right. I think that's the whole idea. So look, we're going to see how it goes. It's in effect though. It's in effect immediately. If you are an organization that sends marketing comms out, you need to be registered. There is a fine. There is a fee for registration, and that's going to be something that affects businesses. So I'm really interested to see where it goes.
That's very interesting. I actually wasn't aware of this, so you've taught me something very interesting I need to consider carefully, and I might reach out to you in terms of a few things that we want to do as well to stay within the guardrails. But my immediate response to hearing this now for the first time was, what's going to happen to these robot calls? Because my goodness, it would be great to opt out of that in an efficient way. But I hear you also in terms of there needs to be a happy medium where you can also market other, other than spam robot calls.
Yes,
So it is an
yeah.
interesting, it
I,
must
I
be an interesting time for you. I can only
I
imagine.
I think it is interesting, and it actually snuck up on us. There was no, I certainly wasn't aware of this development. We did a direct marketing course last month, and at that point there was none of us were, was aware that this was going to actually have any have any impact. So it is going to be interesting, and I do feel sorry for those organizations that need to adjust their activities. And it is an area the information regulates, and not just the, from a Poppy perspective, not just the Consumer Protection Act, regulator side, but the privacy regulator is very intent on making sure that organizations do approach direct marketing as cleanly and transparently as possible. So this just adds another process for organizations that complicates an already practically challenging process to begin with. So I
Mm.
think it's going to be interesting. All
Yeah,
right.
no, let's see.
Yeah. Let's see. All right. So our next segment is called In Practice, Bernard. And what we do in this segment is you and I, we discuss a challenge or a situation we're currently dealing with that could be relevant to those people who are listening to this episode. So we bring something real world experience into the conversation, any practical insights we have on technology or regulatory or contractual issues that our clients are experiencing at the moment. And you've really done a very nice job of explaining the various types of work you are busy with. But I thought I would share that just from my side. I have been working on kind of not a very complicated issue, but I think relevant for a lot of organizations, may be relevant to your space as well, I think, but POCs and, proof of concepts. And I have a client that's a health tech company. They're really impressive and are doing, have scaled so quickly over the last few years, and they service a number of hospitals and healthcare institutions. And they are at the moment tendering for a service at one of the hospitals, and it involves, the deployment of their platform, and they're going up against a competitor as well. They're in that final stage of making offers, and the client or their hopefully their customer wants them to come in and defend not just their technology but also answer questions about their privacy posture and their cybersecurity posture as well, because it is a highly regulated space, being healthcare, and a lot of data being processed related to patients. There's, healthcare legislation, there's privacy legislation. So they want to make sure they're dealing with an entity that is compliant. And I worked on all their privacy compliance initially and over the years. So I'm going to be helping them with those representations in that session. But I think the matter is interesting to me because a lot of, and I welcome the approach by by the potential customer here, because that's exactly what we're wanting. We want people to make sure that they're getting into bed with the right partners. They are interrogating the software they're getting, the technology they're getting, to make sure that it is compliant, that it is secure, because it's ultimately going to be, a lifelong engagement, and you want to make sure that both organizations are managing things properly. So I think it's really good to see that, and I love it for my clients as well, because it helps them, it reinforces their own positions, their own attitude towards how they deal with their customers and their technology. So I think that's quite interesting that I'm dealing with that now. What about you? What are you? What is I know you mentioned a lot of matters that you're working on, but anything interesting at the moment that you're busy with, or yeah, something exciting?
Yeah, no, I wonder we might be talking about the same client, but we'll discuss that
Discuss it
offline. But
offline.
um, yeah, I've if it is the same client, I think South Africans are not even aware of the type of innovation happening behind the scenes, so to say. A lot of the companies that are forward facing and seem very simple are actually involved in such groundbreaking technologies. Such a great space to be in. I think you and I see some of the frontier technologies developing.
Mm,
And the nice thing is that patents are public. So some of these companies are, if you can just search for what they're doing on Google Patents, and you will likely find some of the patents that are out there, and even abroad. If you want to look at what the new Apple inventions are going to look like, they'll file patents sometimes even a year before the products become commercial. But I thought that would just be something interesting for some people to go have a look at what
mm,
those companies are doing. But one of my interesting projects, just a timeline of how it usually goes. So, client would come to me with a new invention, and we will typically ask for something called an invention disclosure form that just describes the invention. And then at first glance, I need to assess whether it is something that is patentable, because there are some exclusions in our Patents Act. And then once we confirm that it is patentable, you perform a search if the client wants to. If they're quite confident that it is new technology, they will opt to just straight up file a patent. But for this particular client, I will be discussing quite broadly, the same as you have. But we performed a search, and then you need to determine if the technology is actually new on a global scale, so to say, because myself, I've also thought something that I developed was completely new, and then you actually do a search online and you find someone patented it in the Philippines or Vietnam 5 years ago. So it really is something you need to assess globally if your invention is new. And this particular client, we got quite a good search at the time, and we were quite confident. We then filed a series of patent applications, and they were all found to be novel and inventive, which are some of the criteria for a patent, in various patent offices across the world. And this client is actually completely pivoting out of their current sector, and they're starting to use a lot of their data that they have over decades. It has been anonymized, but this anonymized data is now being ingested by various different models for different purposes. And these models have been structured to actually take this anonymized data and output very user-specific or sector-specific insights that guides their products that they can offer to clients. And it really is quite special if you see the end product, how it has been tailored to each specific client, because you get these SMSs and robocalls and whatever, and they're so broad and vague, this funeral policy, or 3 gigs of data if you do this and that. And these user insights actually give very bespoke products, and the clients are extremely likely to purchase them just because they can now be segmented or categorized into these different user groups. And it really is powerful. I don't know if the products are completely 100% being rolled out, but just from the patents I've filed, I think it's going to be quite powerful. And it just goes to show these companies that actually are gold rich in terms of data. I mean, we can all agree that it's a new gold currency, data. And if they have it already, instead of licensing data or going out to now procure or receive all of this data through various processes or surveys, they can actually develop some very interesting products. So I'm sure some people are interested. They can go and search patents online, and they will actually see what I'm talking about. But let's keep it broad for now. So that's one of the very interesting projects I've been working on, actually for a few years. And a lot of these patents are being granted now. It's so interesting to see.
Yeah, so you've been walking the walk with your clients, I guess, over this period, as well as they've been pivoting out of their sector.
Yeah, absolutely. For
Um,
several years now.
sure. That's really cool. You must send me the link. I mean, is there a link, or is it you literally just Google patents out there?
Yeah, so the purpose of patents are just not to get into the weeds too much, but patents are supposed to be public, because you can only imagine patents grant these negative rights. So it's going to stop the individuals in the country where the patent has been filed from performing certain acts. So you can imagine, if you've now developed this interesting tool and you want to stop third parties from using it in the country where you filed your patent or your design, this patent or design gives these rights to stop other parties from making, using, exercising, importing, advertising. It's got this list or bundle of rights in the Patent and Design Act. And they need to be public. So on the South African database, you can go search on IP Online, it's called, and you can find these patents. They're not always published in full, but on a global level, Google Patents, I mean, you can just search for the entity's name and you will find hundreds and thousands of patents, for example, for Apple. And you can filter by the recent ones filed and by which firm. And it's quite easy to find. One thing I always like is if a client is involved in quite a fast developing field, I like to show them how to use Google Patents because you can see what your competitors are doing
Mm,
and actually learn from it. It's such an underutilized, how can I say, wealth of knowledge and
yeah.
research and development insights because a patent document is as extensive as a science publication or an engineering publication. It really is a comprehensive document. So yeah, you can
I
find it
must
easily online.
I must actually check this out because there's so many ideas that I just, ideas in the shower that you just come up with. And then you're like, I wonder if someone else has thought of this idea. Maybe I should do something with it, leave my life in law, and then just pursue this other thing instead.
It's a bit of a black hole. I would caution you.
Yeah, you're in the field of invention. You must get tempted.
Yeah, no, I think a lot of patent attorneys, you're just surrounded by all these
Yeah,
amazing engineers and innovators.
yeah, it's inspiring.
So you are, how can I say, tempted for sure.
Yeah. Okay, so Bernard, the next part of the episode is called clause or concept of choice. It just depends on the guest what is relevant to their area. So I ask my guest to bring a clause or a concept of their choice and just speak about what about that is interesting to them or why they think people need to be aware of it. So what have you brought for us today?
Cool. So it's a bit of a broad comment, but I think it's extremely important, and I think it might you might see it in your everyday advice to clients as well. But what happens usually is someone does not have the finalized product, or they might still want to develop something for a while, do market research, or maybe raise some funding. And they've got an interested third party that might fund them. So now they need to disclose their invention to this third party, but they haven't filed a patent or design yet. So to protect their rights, at least to some degree, a patent and a design is always going to be first prize. But second prize, so to say, would be these non-disclosure agreements that everyone will recognize as this powerful document to now protect yourself from disclosing all of your intellectual property or idea or innovation and technology to this third party. And you think that this non-disclosure agreement that you quickly downloaded from some template or chat GPT
Mm,
crafted this NDA for you, and you think I am completely protected by this document. I'm going to have this third party sign. But it really is a big problem in my field, and I definitely think it will be in yours as well, that these vague documents that they download online or have these LLMs draft, it actually doesn't specify, firstly, how their IP rights are defined and how the nature of the disclosure, for example, who owns the IP that might be developed after a certain period. It can really be so vague and leave a lot of room for interpretation. Now, what happens is years later, you actually find out that this third party with deeper pockets and more resources, they've gone and said, yeah, I heard about this idea from Peter and I signed this non-disclosure agreement, but why do I need them? Why don't I just put my 4 developers to task and develop it myself? I'm gonna save a lot of money and make lot more money. And now you say, okay, cool. I've heard about this now. I don't have a patent or a design, but I've got this contract that they
mm,
signed. And now you try and enforce this document, and it's so vague, it doesn't speak anything about what you discussed that day. And now when you try to enforce it in court or whatever the case might be, you've got no clear delineation of your IP rights. And it is a massive problem, Priyanka, because I feel like there's an over-reliance on people trying to do things cheaply, let's be honest, by
Yeah.
downloading these templates and having them drafted by these LLMs. But it's, you're spiting yourself by not securing your future rights, by trying to save some money at the beginning. It really, really is a big problem. I would caution everyone against it. Rather spend some money at the beginning to secure and protect your rights efficiently. You will really regret it later on when you've spent a lot of money developing this technology and you really can't protect yourself. So it's a bit of a broad comment, not necessarily on clauses, definitely important IP clauses in NDAs, but I think that's such an important point I wanted to raise today.
No, and I think it's a point excellently made, Bernard, because you're right, we also see it. And I think it's people um are really rushing to get a deal signed. So they take all these shortcuts, whether it's from a customer perspective, where there's like, oh, they're getting someone to come do a demo or whatever the case is. They just want to quickly get it done and sign their T's and C's and, get the service. Or from the other side, where it's someone who it's their technology that they're trying to sell, and they're so keen on making that sale that they will take shortcuts. Some of them don't even have an NDA. And
Mm.
then, everything is good faith and all laughs and jokes, and then the issue comes up down the line. So yeah, I love it. Thanks for bringing that.
Cool. Yeah, I think it's an important takeaway from any discussion is shortcuts. You're going to be happy saving a few bucks at the beginning, and then you're going to come to me when you've got no options. And I am the unfortunate bearer of bad news, that we're in a very difficult position to take on this other party. So and I had nothing more than seeing a great innovator being done in by a few missteps at the beginning. Um, and I think a lot of people think that patents and NDAs and these type of things are extremely expensive, and it really, really is not the case. At least in South Africa,
Mhm.
really, take it as some minor input costs to protect yourself that can really, really benefit you at a later stage.
An investment, really, rather than, an expense to that
Yeah,
that can feel burdensome. Yeah.
not agree more. Yeah, perfectly put.
All right. Now, to close things off, I'm going to end with a quick game. So it's a chance for any rapid fire views from you on risks or trends or debates that shape tech law or regulation today. And the game I have for you, Bernard, is called To Patent or Not to Patent. So I'm going to give you a few scenarios, and for each of them, you have to choose patent or don't patent. And if you have to justify, we are all lawyers here, so I think it's a bit difficult to resist, but if you have to justify, do it quick. Okay,
Okay, all right, I'm
right. First
ready.
scenario is a new algorithm improving processing speed.
Yeah, I would patent. Are we going to keep it quick, or should I have one sentence for each of them?
I can tell you once a sentence for each, so you can give me a sentence.
Okay, perfect. Now, I think for this first one, the US Patent Office has actually used this as an example of something that could very well be patentable. So definitely
Okay,
patent.
there you go. Next scenario, user interface improvement.
Not patent, rather file a design. And Apple actually
Interesting.
files a lot of designs for their UIs.
Oh, interesting. Okay, now I have a question on that. What's the difference
Between a
between a
patent and a
patent and a
design. Okay,
design? Yeah.
perfect. So it is a bit of a interesting point because they sometimes conflate it. But so patents are for the underlying concept or technology, method, process, apparatus. Designs are for the aesthetic features of something. So think
Mm.
Coke bottles, Crocs, Apple watches, these very uniquely shaped objects. That's where designs come in, and
Okay.
where it has actually been used for UIs is this layout of the different apps. Apple has actually even filed designs for the layout of their stores. You know, I've heard such
Mm.
interesting stories
That's
about they
cool.
had a team of psychologists look at the layout and how to encourage people to purchase items in their stores. So they actually filed designs for the shape of their stores. Very interesting.
Wow, that is cool. Third scenario, internal automation tool.
This one I will be the lawyer and say it depends. Um,
Okay.
yeah, if it's very simple, like as I said earlier, a simple Python script that just spits out some template, that's not patentable. If it's a model that actually trains from historical behavior of the user and really has some unique output, then it might be patentable.
Okay. Fourth scenario, AI model architecture.
Yeah, definitely patentable, and thousands being filed for AI model architectures every month
Huh.
across the world.
Next scenario, business method implemented in software.
Cool. On the face of it, not. Our act actually says that business methods are not patentable, but I had this caveat earlier. Just because something includes a business method does not exclude it from being patentable. One example is Uber actually has a business method patent for how it dynamically adjusts their rates when there's more traffic, etc. I heard
Ah.
this was a bit on full display when this Live Golf event was being hosted. The prices shot a bit up.
Oh.
Yeah.
Okay, and the last scenario is security protocol.
Patent. I'm going to continue my trend of not just giving yes, no answers. Sorry. Um, we all remember, or some of us, that BlackBerry used to sell phones, and that was their major revenue generator.
Yeah.
Today, they're actually managing about 42,000 security-related patents,
Ah.
and they are just licensing out the underlying technology for billions of dollars every year. And they're actually still quite an active company, and I don't know if a lot of us are even aware of it, but
How was
we
that?
thought they went away. They're actually quite active. It might be a bit more in the US, but very interesting how they pivoted. I must think they saw this race of developing new phones every year, and they just said this it's difficult to keep up.
Nah,
Let's
yeah, I,
pivot.
I, I thought they were made redundant. That's a really cool fact. Thanks.
Yeah, no, it's very interesting.
All right. Okay, Bernard, that's a wrap on today's episode of Legal Bites Over Coffee. Thank you so much for joining me in this conversation and sharing all your insights. And
Only a
to
pleasure. Yeah.
Yeah, and to our listeners, if you found this discussion useful, subscribe and join us again as we continue unpacking the legal bites behind Africa's digital economy. Until next time, keep the coffee warm and your governance questions hot.